4th Arthuria mock debate tournament. We have Flacyd, we have Deonteleologist. Flacyd has taken the position that we should have laws prohibiting women going topless in public. Deonteleologist has taken the opposition. As always, when we're based upon who concedes, we don't get a concession. We'll put to a voting poll in which you, the audience, can vote on who you think performed better overall in the debate. You guys will have 40 minutes for this debate. You can get started.
Okie dokie. Deon, I will yield the floor to you to get started.
Oh, I yield it right back to you because I'm taking the opposition.
Okay. All right. So I guess I'll just start out with clarifying the proposition and the side of the proposition that I'm taking, that there should be laws that prohibit women from going topless in public. And that is a true statement. That is the position I'm taking. But I believe that there should be laws prohibiting anyone from going topless in public to prohibit fair and equal treatment under the law. Now, this does not mean a total and all out ban on public nudity or toplessness. It means equal enforcement of the laws as they're reasonably applied. So, if you go to a nude beach, you can expect people to be nude. There would be no law prohibiting that. If you go to Toys R Us, everybody should be clothed.
So wait, I'm curious about the definition of public here because presumably the inside of a Toys R Us is not public. That's a private establishment.
So, I mean, that's fine. We can limit it to purely like public public owned spaces if you would like. If you're in a public park somewhere, maybe it's not reasonable to go topless.
So just so I'm clear though, the proposition we're debating, I need to go and just like look at it word for word.
Yeah.
And that is, where is it? Where would I find this? Tournament Saloon?
Yes. You have to scroll up
And
a
it
little.
says, okay, we should have laws prohibiting women going topless in public versus we should not have laws prohibiting. Okay. So right, my position is that we should not have laws prohibiting women going topless in public.
Right.
And so I mean, you've clarified that you think it's that we should have that the law should be applied equally. So whenever there's a law prohibiting women from being topless in public, it would also prohibit men.
I mean,
But
that's close to my argument. My argument is we should have laws prohibiting women from going topless in public because the laws should prohibit everyone.
right. So what's the argument for prohibiting people from going topless in public?
It's all about the environment in which you're topless. It's about the expectations you have when you go into a public place. People have different expectations about the kind of conduct that happens in public places, and this isn't limited to just the clothing that people wear or the lack thereof. It's the way that you conduct yourself in public. It would be totally unreasonable for me to act the way I do in my private home in public. And even though it may not be offensive to everybody, the fact that it would be largely offensive to most people there and that they weren't expecting this to be going on when they went there is the kind of interest we should protect to try and create cohesion among the public, to try and respect everybody's interests in going into public and not prohibit anybody or make them fearful to go into public.
Okay. Okay. So I'll start with one of my counter arguments. I have two, but I'll focus on this one first because I think it's relevant to what we're talking about now. So this is the argument from the harm principle. So I'm sure you're familiar with John Stuart Mill. He famously coined this harm principle, which is basically the foundation of pretty much all liberal civil societies as we have come to develop them in the past 200, 300 years. So the harm principle states the only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. Right. Premise two is women being topless in public does not cause any harm to others. Conclusion, we may not rightfully enact laws preventing women from being topless in public. Now, the central the force of the harm principle relies crucially on a distinction between harm and offense. And interestingly, in your argument for enacting laws that would prohibit women from being topless in public, you relied on the notion of offense rather than harm. I think the problem with offense is that anyone can be offended at anything, but the question of whether someone was actually harmed by something is a much more objective question. So I'd like to see your justification for making offense the basis rather than harm.
So here's one harm that is that we can talk about. So it goes beyond offense, in that if we allow anyone to be nude in public, I believe that there would be people who would refrain from going into public because they find people being nude or topless to be so offensive to be against their religion, that their very seeing of this person topless or naked is a sin in their religion, and so they don't go out into public because they want to prevent that. And so while the offensiveness is not the harm in and of itself, the fact that the offensiveness is prohibiting people from going somewhere they otherwise would be entitled to go is a harm.
So that's a fair point. You can say that that's the harm, but then the argument based on religious freedom can be used right back against you, because somebody can argue that it is an expression of their religion to be able to be topless in public, and that preventing them from being topless in public would be so offensive to them in their religion, and that wouldn't be the harm in itself, but that the harm would be constituted by their actual refusal to go out in public because they wouldn't be able to express their religion.
So here's how the freedom of religion clause works, though. As long as the law is equally applied to people regardless of their religion and independent of their religion, it does not violate the anti-establishment clause. And so because this applies to
That's
everybody
fine.
independent of their religion, it is not a violation of your freedom of religion.
Right, but then the point can be made right back against you is that the ability to go topless in public would be applied to everyone, regardless and independent of their religion as well.
Right, but I believe that your end of the proposition is that there should be no laws. That it isn't a law stating that you are allowed to do this thing. It is saying that there should not be laws that prohibit it. We're talking purely
Right,
about the
because
prohibition.
and that's based on the harm principle. And you're trying to argue that there's this harm in one side, and what I was countering with is that there would be harm on both sides, whether you allow it or don't allow it.
I mean, I think
Using your
there's a
definition of
greater, I
harm.
think there's a greater harm versus the very minimal harm of having to wear a shirt in public places where nudity is not expected. I think that's a very minor harm to the person. I think a secondary harm could be that because so many people find this offensive, and that even right now where we have people not going topless in public, specifically women not going topless in public, we see a lot of violence towards women based solely off of what they are wearing, and we can expect to see that to continue, if not increase. And while I'm not arguing that it's women's fault for wearing provocative clothing or not wearing clothing at all, it is still a reality that we're facing, and until we can mitigate some of this violence towards women, it's not responsible to instigate it.
So I can understand this from an intuitive perspective, and that sort of thing sounds like the sort of chain of reasoning that would be intuitively plausible. But what's intuitively plausible isn't always backed up by the data. So I would ask you, is there any evidence that in societies that where there are a proliferation of places in which women can actually be nude or be topless, I think we should try to stick with the phrasing topless in public, because nude suggests fully nude, and I would be more sympathetic to those kinds of laws. But putting that aside, is there any evidence that in places where there are more areas in which women can be topless, that there are actually more cases of sexual assault?
So the evidence you're looking for couldn't be found because in places where women are topless just as much as men are topless, and it's totally integrated into the culture, you don't have this offense that is instigating violence towards women.
So your argument is now that it's the offense that instigates violence towards women.
I mean, plenty of things can instigate violence towards women, but until we can figure out a way to come up with a more responsible society where people aren't attacking women for their sexuality and for what they're wearing or what they are not wearing, it's not responsible to continue full steam ahead.
So at the places in the United States, I'm assuming we're both in the United States, are we?
Yes.
Okay, so in the United States, where we have these nude beaches and such, are there any higher or perhaps are there lower rates of sexual assault or sexual harassment?
So again, you're going to have the same problem looking for that kind of evidence because it is expected that you're nude on a nude beach. Nobody goes to a nude beach and then is shocked that people are nude. And to take that a step farther, the laws that I'm proposing wouldn't apply to nude beaches because I'm simply saying that places where it's totally irrational for somebody to be nude is where we should have laws preventing people from being topless.
And if society were to shift to prohibit all such laws preventing women from being topless, how could we know that it wouldn't end up just being all like nude beaches where the expectation shifts with the laws?
So if there's no more places where it's unreasonable for people to be nude, there might not be a use for the law. However, that's not the situation that we have currently. Right now, most places it's considered totally unreasonable for somebody to be topless.
Most places in public?
Most public places, it is considered abnormal, offensive, and unreasonable to be nude.
To be topless, right? Like let's
Right,
try to stick with
topless.
that phrasing.
You're right.
Because
Yeah.
because I think that you know, most places, right, it might be totally unreasonable for people to be for people to not wear shoes. And yet that doesn't give us any reason to impose laws that people must wear shoes in public.
I mean, there are rules saying that you have to wear shoes in public.
I've never seen any such rules that you have to wear shoes in public. I've always seen rules about, whether people are allowed inside certain stores or certain other private places um, in public.
I mean, I think one public place where it is considered. I don't know that there is a written rule. I would have to look, but I do believe that there are places that have written rules saying that you do have to wear shoes, but that's neither here nor there. Can
Okay.
you imagine somebody showing up to a courthouse, which is a public place, being topless?
Um, but I mean, these are it's not the same kind of public place as I would imagine the most charitable construction of the debate is going on. Whether you can have rules inside of a courthouse uh, as to whether there should be laws, I mean, because it's also true that you do need to be wearing shoes inside of a courthouse. If we're debating over whether there should be laws inside a courthouse, then I guess the proposition has fucked me over because
I mean,
there's
it's
just
not.
no way.
I'm using courthouse as an example, and I'm not saying that every public place would have a total prohibition on being topless. It's those public places where it is expected that somebody will wear clothes.
Right. So I mean, if there is, if if the way that we're supposed to interpret these is that uh, the person who's arguing for my side of the proposition has to argue that even in a courthouse there should be no such laws, then I give up because that's a ridiculous thing to argue. But I'll now bring out my second argument. My second argument is the argument from external freedom. So Immanuel Kant has this idea of external freedom, which he treats as the basis of a civil society. So his basic principle is the what does he call it? I forgot exactly what it's called, but he says that the only uh, the only thing which can prohibit the external freedom of a citizen is infringing on the external freedom of another. So the idea is, look, the only thing that can prevent me from taking up my means to my ends is that doing so would infringe on your ability to take up your means to your ends, right? And so what he takes us to argue, and I mean, the metaphysics of morals is very long tracked, and to get into it all here would be excessive, but what he takes it to argue is that, look, my freedom in a civil society, my ability to exercise my freedom should never turn on the choice of another person, right? So what he takes this to mean is that there must be some provision for public land, some provision for public housing, for public food, and generally for public assistance for the very poor. Because if there's, for instance, if there's in a city, if there's no public land whatsoever and everything's private, then my very ability to exist as a citizen in this city is always going to be subject to the choice of another person. I can never be anywhere without someone else's permission, right?
I mean, can
Does this
I
make
interrupt quickly?
Sure.
So legally speaking, there are places that are technically privately owned that are still part of the public sphere. Most stores and almost every establishment that is open for people of the public to come in, even though it is privately owned, is a public space.
Right, but because of these public spaces that are still privately owned, they get to have rules like no shirt, no shoes, no service, right? And so there are specific requirements that I must meet in order to exist there. And I can't just exist there whenever I want. They have hours, they close, they can kick me out of the store.
Right.
Right. So what Kant argues is basically that unless there is some public land where people can exist no matter what, right, then my very existence as a member of this society is always contingent on the choice of another person. Does that make
Okay.
sense? Right. So if
I understand the statement. I'm not sure I understand the argument.
right, no, I haven't gotten to the through with the argument. So the argument is that there if there's going to be rules like people must uh you know if there's not going to be a public provision of certain goods like socks and shoes and clothing for people to exist in public, just merely to exist, right? If there isn't those things, then we're not justified in making laws prohibiting nudity, because it's not on a person who does not have the financial means or who does not have the material means of clothing themselves. It would be completely unjust to punish them for failing to do something that they don't have the means to do.
Sure. It would be unjust to punish them, but that comes under prosecution, that comes under writing the laws. Every law has exceptions to it. And I think it would be, I mean, it's a generally understood defense in common law to say that it's impossible. It is practically impossible for you to obey the law. If you are simply so destitute and so poor that there is absolutely no way that you could acquire clothing, that would be a defense. That would be a defense. It is purely impossible for you to comply with the law.
Right. And so my argument would be that we should refrain from making these laws that prohibit toplessness from women or men in public until we have actually secured the means for them to, the public means by the government or by the state, that would prevent them from violating these laws through no fault of their own.
So
And right now, we don't have those means.
anecdotally, I have never seen somebody so impoverished that they don't have any clothing, but that's not to say that it couldn't happen. It simply could happen. But just because every other law is subject to this flaw where it might be physically or subjectively impossible for somebody to obey the law doesn't mean that the law is no good. we don't legislate based off of the hypothetical infringed cases. We legislate based off of what is the most likely and what is the most probable person.
Okay, well, that's a flaw of our current legislation.
That we don't legislate for the masses?
That we don't legislate on principle. We legislate in which leaves a lot of room for people who don't have the means to secure a good defense attorney, or to even go through the full process on their own. If they don't even have the means to clothe themselves, then they can't even participate in the juridical process itself. So, I mean, you can argue that this is not how we do things currently, and I'll say, fine, how we do things currently is shit.
I mean, sure, but I still think that because every other law is subject to the flaw of it may be a practical or subjective impossibility, doesn't mean that we go into a lawless state. So even if we aren't legislating for the masses in the most probable and practical way, still every law that you could possibly come up with could be subjected to an impossibility principle.
I don't know what an impossibility principle is.
That there could be a case where it would be impossible for somebody to follow the law.
So I don't think that that's exactly my argument. It's not that it's impossible for somebody to follow the law. It's that the way that our current system is set up, it makes it such that the only way someone could follow the law is through private charity or donation, basically relying on the good nature of another person in the society.
If they have no way of getting their own clothing. I mean, we do have government assistance that would help somebody if they are, so destitute or they simply cannot provide for themselves. We do have government assistance in every state that could provide for them. And it may not be dropping off a bundle of clothes, but it might be having somebody in the government look after them.
Don't you need an address to enroll in these programs?
No, no, if somebody is like so mentally ill and homeless, there are government assistance programs for them that you do not need an address.
Well, that's nice, but the way I understand it right now, there's no absolute public provision of, there's no, safety net that would provide for the most the complete least well off who would rely on these programs completely. I know that your legal knowledge is definitely way above mine, but I mean, why do we still have homeless people if these programs exist? Are they just not executing themselves effectively?
I mean, we're not talking about solving homelessness here. I mean, so homelessness is a multifaceted issue that takes a lot to solve, but I mean, just simply clothing people, we've got that down.
Well, right, but that's not, we don't do that through the government.
I mean, when somebody is taken into government care, they are given clothing.
But we do that generally through charity. How do we?
Right, so somebody can do it through charity, and I mean, there is some government assistance in allowing charities to exist, but even more directly, when somebody is taken into government care, they are given clothing.
Right, but when they're taking into government care, and right now we're talking about the applicability of laws in public. That's not government care.
I mean, if the government can provide clothing to people, I'm not understanding how this is.
The government can provide clothing to people, but right now there's no system ensuring that all people have the means to clothe themselves at all times.
All right. I mean, there's nothing that says that we are going to allow everybody to always make their rent payment all the time, but we still allow landlords to evict people.
Right. But even if you don't live at a place where there's rent, right? There are these laws of clothing oneself that apply to everybody in public.
Right. There's also laws against not paying people the debts that you owe.
Yeah, but deciding to go into debt, that's a choice of yours, right? But but clothing yourself is is something where if you make a certain choice, right? The disanalogy is you don't ever have to enter into debt versus if you do not clothe yourself in public, you can be arrested and taken to jail.
Right. If I don't pay my landlord, I can be evicted and then he can sue me for back rent.
Do you not understand the disanalogy here? Because you don't have to enter into an agreement with a landlord, but you have to exist somewhere. And if you don't exist in a private establishment, then you exist in public. And if you exist in public and you don't clothe yourself, then you're going to jail.
I mean, existence, as terrible as it is that we have laws that prohibit somebody's existence in places, doesn't mean that those laws are bad. I mean, you can
No,
be
so that was my
unlawfully
art, right?
present. You can be unlawfully present somewhere, and that has nothing to do with what you're wearing, how much money you have, or who you are. You're simply unlawfully present, and your very
Right.
presence in this public space is unlawful.
That's in a certain public space. My argument is based on if there's nowhere for you to exist at all in a society, at all,
No, that's the
anywhere.
exact argument I'm making. To be unlawfully present in the United States mean you are not allowed in the United States. And whether or
Okay,
not you
okay,
were
you're making a
trafficked
difference.
here,
This is
whether
an
or not you were
equivocation.
trafficked here, whether or not you choose to come here, whether or not you were born here and through some way you're now exiled from the United States, simply being unlawfully present means that your presence within the boundaries of the United States is unlawful.
This was an equivocation of presence. I was assuming that the person here was a lawful citizen.
Right, but what the analogy I'm making is existing in public. If you're too poor to afford clothes, your existing there is unlawful. I'm saying we already have laws that are valid and good laws that have been upheld for decades, if not close to a century, saying that your presence is unlawful.
Okay, I'll go through it very slowly. The first, there's two sides of the analogy. The first is a lawful citizen, right, whose existence in a public space is criminalized because they lack certain clothing articles. The second is someone whose existence anywhere in the United States is criminalized because they are not a lawful citizen. There's a disanalogy there.
I mean, the analogy is in both cases, the presence of a person by no fault of their own is criminalized.
There's a presence of the lawful person, the person who is there lawfully, who was born here, right? Then we can have a separate argument about the righteousness or the lawfulness of immigration laws, and I suspect that I'm on your side. But you have to acknowledge that there's a disanalogy there, that there's a difference between someone who's a lawful citizen who is being prosecuted or arrested because they don't have a certain clothing article in public, and someone who is, for any other reason, an unlawful citizen who is prosecuted for their unlawfulness itself.
Right. So I mean, they're not perfect mirror images, but the same principles apply.
I disagree. But I mean, I'm going to go back. I think we're pretty much talking past each other at this point. I'll let people decide whether they think that there's an analogy there or not. Let's see. How much time do we have left in the debate? Not much, I imagine. I haven't been looking at the debate chat.
11 minutes.
11 minutes. Okay. I mean, I still, let's see. The argument from the harm principle, I'm still, that wound us up in you cornering me in like the public courtroom thing, and that I'm just not sure. I'll leave it up to people to decide whether they think a charitable interpretation of my proposition precludes there being laws inside a courthouse. I mean, you're in the advantage there because you know the nuances of whether that's a private or a public establishment and whether and how that all works. I just simply don't. But the argument from freedom, I'll just restate here. The argument from freedom says that just as there must be some public land, there must be some public assistance. Otherwise, a lawful citizen's very existence is subject to the will of fellow citizens. But there is currently no public provision of clothing for those who lack it. So making it illegal to lack clothing in public would infringe on freedom. To make it specific to one's sex or gender would be worse because it's discriminatory. You already acknowledged that you wouldn't want it to make it specific. The third premise is we may not pass laws that unwarrantedly infringe on the freedom of our citizens. Therefore, we may not rightfully enact laws preventing women from being topless in public or men from being topless in public.
All right, so for my clothing statement, for my closing statement, I'm going to go with the fact that I'm simply arguing the proposition as it was given. And I'm not arguing for an all-out ban on all toplessness in all cases. I'm saying in those very limited public spaces where toplessness is inappropriate and irrational, that's where we should have laws prohibiting toplessness. And while my opponent might think offense as a harm is insignificant and insufficient to prove harm, I think I've demonstrated other possible harms that we're already legislating against with public nudity laws and indecency laws. And I do believe that the government has done a very good job in providing at least clothing to people. But even in a world where they have not, because I'm advocating for a position where it's not such that every public space that toplessness is illegal in every public space, there would still be public spaces where toplessness would be allowed.